Further hearing in the appeal Totel Limited against Commissioners for Her Majesty's Revenue and Customs.
Yes, Mr. Stewart.
My lady, yesterday afternoon I'd just taken you to the judgment of the Court of Appeal in Littlewoods, paragraphs 134 and 135, and the court there had identified the comparison as one that needed to be in relation to similar claims, and had concluded that the only similar claim was another VAT claim. My lady, at that paragraph, 135, the Court of Appeal cross-referred to the Court of Justice decision in Littlewoods. Just for your note, it's paragraph 27, which is file 3, tab 22 at page 845, and there the court, in the usual words, restates the need for a similar domestic action. And also on the same page, in the Court of Justice judgment, paragraph 31, there the Court of Justice again repeats the often stated principle that it is for a national court to decide what is a similar claim and to identify whether there is any less favourable treatment. So
Can that be right in relation to something as pervasive as VAT versus income tax, for example? I mean, there must be a Europe-wide view on that, mustn't there?
Well, my Lord, of course, the judgment of the Court of Justice in Riemsma, I say, actually does come to that point.
But it can't.
But I don't. The fact that there may be some matters which are in fact of universal application, in my submission, doesn't detract from the general proposition. And obviously in Littlewoods, the court, when it deals with equivalence, is doing no more than stating general propositions, that questions of less favourable treatment are primarily those for national courts, simply because they are better placed to make that assessment, because they are in possession of fuller information about the nature of the relevant similar domestic claims.
Do we not have to look at the particular difference which is involved in the debate? In other words, do we not have to ask ourselves not whether VAT is different from income tax, to which the answer is obviously yes, but whether it is different in some respect to which this difference in the mode of collection is relevant?
My Lord, yes, that must be part of the inquiry. May I just take you to Riemster, just to address that point before I make the submissions about Mr. Justice Moses' judgment. Riemster itself, it's volume 3 of the authorities, tab 28, starting at 957. Can I just, it's the same passages that you were taken to yesterday. So if you could go to the Advocate General first, the page is page 999. And on that page, second column towards the bottom.
Sorry, I've lost you. Can you give me the reference again?
My Lord, yes, it's tab 28, volume 3, page 999.
I'm not using the electronic bundle. What's the...
I have the same... I understood that the page numbers were the same.
But I think the trouble is we have two versions, those of us who are still in the dark age of documentary use.
Yes.
One has the right numbers.
Yes,
and one
I think
doesn't.
it was recognised...
Well, if you give us the paragraph number of the Advocate General's...
It's paragraph 93.
That is 999.
And
in the other version, it's 972.
Right. My Lord, I'm sorry for that. Anyway, that page, right-hand column, towards the bottom, the Advocate General poses the question, does it make any difference to that assessment if other national rules in the field of direct taxation allow a joint action? And then paragraph 93, she says, it appears that where income tax has been erroneously retained at source by an intention paid to the tax authorities, Italian law allows both the employer and the employee to seek reimbursement from the tax authorities. Referring court is concerned, the availability of such a joint or alternative remedy in that situation combined with its non-availability for both supplier and customer with regard to a VAT situation of the kind at issue in the main proceedings might offend the principle of equivalence. Now, at 94, the Advocate General refers to the submission on this point from the Commission, and she says, third line of paragraph 94, the Commission considers in general that a situation in that field is unlikely to be comparable to the field of VAT. In the latter, it is in principle only the supplier who is in a direct legal relationship with the tax authorities. Now, that point is clearly specific to the issue before the court in Rinsmar. The notion that the existence of the direct cause of action in income tax cases could be distinguished from the absence of a direct cause of action in VAT claims because it was only the supplier in the VAT case who has the direct relationship with the tax authority. But then the Commission's submission goes on. Indeed, the whole system of direct taxation is unrelated to that of VAT. And at paragraph 95, the Advocate General states her agreement with the submission made by the Commission. If you then go to the court, and this time it's paragraph 45 of the judgment. I have it on page 976. But anyway, it is the last paragraph of the judgment, just above the side heading costs. And the court at paragraph 44 has again, 43 and 44 has again posed the question, and 44 made the point about the need for situations to be comparable. The court only picks up on the second of the Commission's two submissions, saying the system of direct taxation as a whole is not related to the VAT system. It follows the answer to the second part of the second question cannot be affected by the national legislation on direct taxation. So, my Lord, although it is right to say that the question of similarity must be considered taking into account the particular dissimilarity that is in issue in the case before it, Riensma, the judgment of the court, is in my submission authority for the proposition that at a generic level there is a relevant distinction between direct tax schemes and the VAT scheme. And this, of course, is a point that goes primarily to one of Totel's submissions in this case as to the approach that this court should take to similarity. My Lord, returning, if I may, to the submission I'm making as to Mr. Justice Moses' approach to similarity in Marks and Spencer, my submission is that that which is a tax-by-tax approach is the right approach, for these reasons. Firstly, it is entirely consistent with the judgment of the Court of Justice in Edis, and note in particular the requirement stated there at paragraph 36 of the judgment, which for your note is volume 4, page 13, the requirement that the comparator claim be a claim, quotes, with respect to the same kind of charges or dues. Mr. Justice Moses' approach also fits well with the emphasis in remaining Court of Justice case law on a like-for-like comparison, and is in particular consistent with the approach in cases such as Leves, Preston, and Stringer, where the comparison was only between different causes of action in respect of substantially the same objective. In my submission, this tax-by-tax approach provides a clear and manageable standard. As Mr. Justice Moses correctly pointed out in his judgment, if you go beyond tax-by-tax approach, there is no clear yardstick by which to address the similarity issue.
That's because there's no common standard in the tax system as a whole for dealing with this kind of thing. If, for example, you had a national legal system under which there was a general tax code applicable to all taxes, but EU claims were dealt with differently, then you might be in difficulties on the principle of equivalence. But if you have a system under which every tax has its own system, there is by definition no general common standard.
Quite so, my lord. And more to the point, the consequence of the absence of a common standard is that in terms of a similarity debate, if you move away from the tax-by-tax approach, all that would produce would be a detailed but ultimately inconclusive argument about degrees of similarity measured against standards that were not themselves common standards and so were themselves open to debate. That is, of course, until you get to the sort of extreme position adopted by Totel in this appeal, which amounts to saying that if it is an appeal about a liability to tax, then the principle of equivalence requires the same procedures to be applicable to all taxes. So effectively, Totel's submission comes to saying all taxes are the same. Now, I fully accept that the scope for comparison under Mr. Justice Moses' approach in the field of tax is going to be limited, and in relation to VAT will lead to the conclusion that the principle of equivalence has no specific role to play. But I say, nevertheless, his approach is one that is entirely consistent with the purpose of the principle of of equivalence. It meets the requirement that there should be no less favourable treatment of claims simply because those claims arise from principles of EU law. And I say his approach has the further benefit that it is consistent with the long-held view that the principle of equivalence, like the principle of effectiveness, is a boundary provision. It is a boundary restriction on the freedom of action of member states, not a principle that is intended to intrude more generally on the procedural autonomy that member states have, the freedom to organise their own national legal systems. By contrast, in my submission, Totel's position, the more general position, all taxes need to be treated the same, lacks any meaningful connection to the principle of equivalence. Again, it's not directed to simply addressing fetters on EU law-derived claims just because they are claims derived from EU law. It is more towards the need for or the promotion of a uniform procedural code relating to all tax claims. So, for those reasons, I say that the limited approach to comparison propounded by Mr. Justice Moses in Marks and Spencer and accepted by the Court of Appeal in Littlewoods is the correct approach, which produces the conclusion in this case that VAT is to be treated as sui generis, and for that reason the principle of equivalence has no substantial role or has no role to play. My lady, moving from that submission to my second submission. So,
could I just raise one point which has been sort of occurred to me? In EDIS, there's a reference back to a case called Amministrazione delle Finanze dello Stato v. Salumi, which appears to be the fountain of all this.
Yes.
But we haven't got it in the papers, have we?
My lord, you haven't. We can provide that. I have looked at that, and it doesn't take matters any further in terms of statements of general principle. My lord, I'm happy to...
Well, it does. I'm looking at it at the moment on screen, but it seems to be saying you can't have a different system for collecting community charges as compared to things like agricultural levies, which are domestic.
Yes, and so to that extent, it's the same point that the court in EDIS makes, second sentence of paragraph 37.
Yes, but it may be some assistance deciding what is meant by the same kind of charges or dues, because it's assuming that the community charges may be of the same kind as purely domestic charges like agricultural levies and so on. So it may slightly cut across your idea that it's a sort of tax-by-tax approach.
Well, my lord, yes, perhaps I should be more specific. The tax-by-tax approach, in my submission, doesn't rule out the possibility that there will be some instances where there is an EU-derived charge that can be treated as relevantly similar to some sort of domestic-derived charge. I say, but I do say that in relation to VAT, the tax-by-tax approach produces the conclusion that it's only some other VAT claim that's going to be the relative comparator because of the nature of the nature of VAT, which I'll come on to.
Well, it's really because, I mean, you're saying that VAT and direct taxes are sufficiently different
Yes.
not to come within the approach.
Right. So I don't rule out the possibility that if one is dealing with a different EU law-derived charge, there could be, for example, some sort of agricultural levy or something like that. I accept the possibility there could be the possibility of some sort of domestic law-derived relevantly similar action or relevantly similar charge. But that's simply not the situation when it comes to VAT.
Thank you.
My lady, the second submission is that even if VAT is not sui generis, there is certainly no appropriate comparison to be drawn between it and income tax, stamp duty, land tax, and so on. Totel's contentions as to why VAT and these other taxes are relevantly similar are all pitched at a very high level of generality. And my overall submission is that for that reason, they are submissions that prove too much. The principles that Totel would have this court apply would require across-the-board procedural uniformity for reasons that have very little to say about whether EU law-derived claims are subject to impediments simply because of their origin in EU law. Now, that is the overall point. Dealing with Totel's submissions, responding to them more specifically, the first point is to the effect that, both claims are appeals and they are both appeals to the same tribunal. I say there is nothing in that proposition at all. There is certainly no authority for the proposition that all appeals are materially similar for equivalence purposes. And in my submission, any such proposition simply spreads the net far too widely. Look at it this way, if you will. If all appeals are similar, well, why not are all claims relatively similar just because they are claims? Quite obviously, the Court of Justice has never come close to adopting a proposition that is anywhere close to that. As regards allocation to courts, again, I say that that is a point of no substance, just as a matter of detail, and we make this point in our written submission at paragraph 37. Although it is the case now that each appeal will go to the first-tier tribunal, at the time Totel's underlying claims arose, back in 2008, that predated the first-tier tribunal, and at that point you'd have the appeals going to different tribunals. But there's nothing in the point either way. That is the submission I make. Totel's other point is, well, these are all tax appeals. That is to say, similarity is made out because the issue on the appeal will be whether a tax is properly payable. Again, there is no support for so broad brush approach, and I say that approach is completely at odds with the statement in EDIS at paragraph 36, which is in terms of the same kind of charges or dues. It's also notable in my submission that what Totel says is entirely at odds with the conclusions stated by the Court of Justice in the Compass Contract Services case that I took you to yesterday afternoon. My lady, for your note, that's volume 2 of the authorities, tab 17, starting at page 647. It was the case where a claim for recovery of a VAT overpayment was held to be not materially similar to a right to offset input tax. Now, the issue in each of those claims, at least at some level, could have been characterised as being, is a sum payable as tax? But plainly, that was not good enough for the Court of Justice. And again, my lady, if I could just give you references to paragraphs I took you to yesterday, it's paragraph 30 at page 654, and paragraphs 36 and 38 at 655. The next point is a point I've already touched on by reference to the judgment and the opinion of the Advocate General in Riemsma. Again, as I've shown you this morning, the conclusion stated by the court in that case, at paragraph 45, was by reference to a generic statement that the direct tax system is a matter apart from VAT. Now, I say that that generic statement rests on matters, is supported by matters such as those that we set out at paragraph 41 of our written case. Now, those matters, which I'll come to shortly, explain the reason also in this case for a prepayment rule in VAT appeals. So, my lady, drawing those matters together, I say that it is clear that there is no support in any case law for Totel's submission that a relevant comparison can be made between direct taxes and indirect taxes. If I can move to a further point, Totel's argument does not, in my submission, improve if the inquiry is narrowed so that the only matter considered is why a prepayment rule is applied to VAT appeals, but not to appeals such as income tax. So moving from the generic to the specific in this case. On this point, could I draw your attention to our written case? It's tab 6 of the appeal bundle. Paragraph 39 is the starting point, and paragraph 39 is on page 78. Now, at paragraph 39, you find set out paragraph 54 of the judgment of the Court of Appeal in this case. And the point that the court makes in its judgment there is as to the nature of VAT, that VAT is a tax on consumption, that is a tax paid by a customer. It is designed to cover chains of transactions such that each trader in the chain collects the tax from the customer and then accounts to the commissioners for that tax. Now, this being so, I say there is reason for a rule to the effect that in the event of an appeal, it is the commissioners rather than the trader who should hold the money pending resolution of that appeal. Now, it's not just a question of the trader being the person sitting on the money, as it was put yesterday. Equally important is how it is that the trader comes to be sitting on the money, and that is something that is a characteristic of VAT itself, in that it's the responsibility of the trader to collect the tax and then account for the VAT that he's collected. In that regard, a person assessed to income tax or stamp duty, land tax or whatever is in a materially different position. In those cases, and I'll put to one side PAYE, but in those cases, the tax requires the taxpayer to pay over some part of his own funds. There is no equivalent to the customer-trader relationship or distinction. In relation to stamp duty, land tax and income tax itself, I rely on the matters we set out at paragraph 41 of the written case, page 79. And even if one then factors in PAYE in the income tax scenario, in my submission, that does not change this analysis. PAYE itself is as a withholding arrangement. It's a means of ensuring that tax is collected, the tax effectively being deducted at source by the employer, which is then treated as an advance payment of the income tax due from the employee. Now, it's the employee who remains the taxable person, and as I say, the deductions made by the employer simply being treated as a payment on account in respect of the tax liability for the whole year. None of that alters the nature of income tax, and none of that would explain a prepayment rule in an income tax context in the same way that the characteristics of VAT explain that rule in the context of VAT. Finally, on this point as to comparison between VAT and other taxes, I ask you to note that Totel itself advances no positive case as to similarity, save for the fact that these are all claims in relation to tax. The only further matter referred to is paragraph 60 at Totel's written case, which is tab 5 of the appeal bundle. It's page 61. It's the example that Mr. Firth gave you at the outset of his submissions yesterday. Paragraph 57, page 61. It's the example he gave yesterday, that is to say, the example of a situation where, as a matter of chance, a VAT appeal and an income tax appeal might both raise the same factual issue. But with respect, that is an entirely opportunistic contention. The chance that the same factual issue might arise both in a VAT appeal and an appeal in relation to income tax is no argument that the two taxes or the two claims are relevantly similar in any way. May I now move to my next submission?
Just before you,
yes.
You do you want to say anything about Mr. Firth's submission that only one of the three strands of VAT liability puts the trader in the position of a tax collector? He referred to imports from outside the EU and purchases from other member states as being different in that respect.
Yes. Only to say this, my lord, that the existence of those other strands is not a sufficient matter to outweigh the submissions I've already made in relation to what I would describe as the primary strand of VAT.
Yes, I was going to raise really essentially the same point. I mean, there will be VAT appeals where the taxpayer appellant hasn't actually received money from the consumer, and this in itself might be one of those where it's said that I have paid input tax and I have sold on to someone who doesn't pay me VAT on top of the purchase price. I want my input tax back.
Yes.
So you're accepting that such appeals exist,
yes.
but you say, but the fact that there will be many appeals where someone has received output tax and will have a dispute about the extent of input tax to be set against it means that the paradigm allows the distinction to be made.
My lord, yes, I say that this is a prime example of a situation where a bright line approach is entirely permissible, that it's permissible to adopt a general rule that will apply in a particular way and apply appropriately in the overall run of cases, albeit that there might be separate examples of situations where the rule might not be an entirely appropriate fit. But again, that's all part of the margin of appreciation that ought to be afforded to member states. It's part and parcel of the question of assessment of whether the claims are similar in any relevant way. Again, member states, the UK is entitled to look at VAT claims as a whole rather than parcel them up in any specific way. The next submission is the submission on less favourable treatment. So I assume at this stage that you're against me on my sui generis submission. You're also against me on the submission I've just made as to the inability or inappropriateness of a comparison between income tax and VAT. And so the question is whether, if one can appropriately compare VAT appeals with, say, income tax appeals, whether there is any material less favourable treatment. Now, it is clear that there are differences in treatment, but I say it is equally clear from the authorities that differences of themselves do not demonstrate less favourable treatment. If I can give you an example of that, it's in the approach of the House of Lords in the Preston litigation. If I could take you back to this slightly different passage. Preston is volume 1 of the authorities, tab 11. And in my bundle, starting at page 477, but the material part, for the purposes of this submission, is Lord Slynn's speech, paragraph 29, which starts on page 494. And the passage is paragraph 29 through to paragraph 31. He says there is still a 6-year period for contract claims rather than a 6-month claim for infringement of Article 119. So that's the different time limits between a contract claim and a claim under the Equal Pay Act. This, however, is not the end of the inquiry. Merely to look at the limitation periods is not sufficient. It is necessary to have regard to the role played by that provision in the procedure as a whole, as well as the operation and any special features of that procedure before the different national courts. And then a reference to the judgment of the Court of Justice in Leves. On that point, it is appropriate to consider whether, in order fully to assert rights conferred by community law before the county court, an employee in circumstances such as those of the applicant would incur additional costs and delay by comparison with a claimant who, because he is relying on what may be regarded as a similar right under domestic law, may bring an action before the industrial tribunal which is simpler and, in principle, less costly. And then Lord Slynn continued, there are thus factors to be set against the difference in limitation periods. As has already been seen, the claim under a contract can only go back 6 years from the date of the claim, whereas a claim brought within 6 months of termination of employment can go back to the beginning of employment, or 8th of April 1976, whichever is the later. Moreover, the claimant can wait until the employment is over, thus avoiding the possibility of friction with the employer if proceedings to protect her position are brought during the employment, as will be necessary since the 6-year limitation runs from the accrual of a completed cause of action. It is in my view also relevant to have regard to the lower costs involved in the claim before an employment tribunal, and if proceedings finish there, the shorter timescale involved. The period of 6 months itself is not an unreasonably short period for a claim to be referred to an employment tribunal. The informality of proceedings is also a relevant factor. And then his conclusion at paragraph 31, I am not satisfied that in these cases it can be said that the rules of procedure for a claim under section 2.4 of the 1970 Act are less favourable than those applying to a claim in contract. I therefore hold section 2.4 does not breach the principle of equivalence. And the same conclusion on the facts was stated by Lord Clyde, and it's paragraph 45 of his speech, which I took you to yesterday. And so all members of the House were in agreement on that question of overall evaluation. Now, in the present case, you've already been taken to the provisions that relate to income tax and stamp duty land tax. Respectively, the income tax provisions under the Taxes Management Act are volume 3, tab 35, page 1079, and the stamp duty land provisions are at volume 3, tab 31, page 1049. Now, summarising those, there is no requirement to pay the tax to pursue an appeal, but equally, there is no automatic postponement of collection of tax pending an appeal. In the income tax and other cases, there is only postponement of collection if the taxpayer makes an application to the commissioners or the tribunal, and there are reasonable grounds to believe that the appellant is overcharged.
But is that latter aspect, what I would call the postponement of collection, also common to VAT?
In relation to VAT, and I took instructions on this yesterday in light of the Totel judgment that you were taken to. The usual position is that, if a hardship application succeeds, then steps are not usually taken to recover the VAT.
That's a matter of administrative discretion rather than
yes. In relation to Totel, just to explain that, Actually, perhaps I could ask you just to look at that briefly, just so you have the circumstances in front of you. It's Volume 1, Tab 6, at 303. The facts of the case, or the circumstances, there's the briefest of sketches of them at paragraph 2 of Lord Justice Foster's judgment at page 306. And when you get there, you will see that it was a situation where the winding up petition had been made on the basis of 15 VAT assessments. In total, there had been some 36 assessments, 34 of which had not been paid and which were under appeal. And then at paragraph 3, you see further that this was, the situation was said to be, by the commissioners, an MTIC situation, a missing trader fraud situation. Then paragraph, just two further reference points in Lord Justice Foss's judgment. Paragraph 72, page 315 at the end, he recognises that the circumstances in Changtel were exceptional. And just to give you an idea of what that exceptionality meant in that case, if you turn back to paragraph 57 on page 313, under the heading, were the debts based on the dispatch assessment disputed in good faith on substantial grounds. He says at paragraph 57, to put the matter shortly, the discrepancies that HMRC has highlighted in relation to the supposed export transactions are simply too numerous and too clear to admit of any conclusion other than that export did not take place as the company contends. There is, moreover, no real issue as to whether the company is implicated in the fraud, because it is the company that has put forward the evidence that, in my judgment, must be regarded as false. The company cannot say it does not know the goods were not exported in the manner that it claims they were, because it has promulgated documents and evidence that can be shown to be simply unsustainable. In that situation, the principles enunciated in the judgment in Telios, on which the judge relied, cannot avail the company. So rather exceptional
But
circumstances.
he says in the following paragraph, the normal case, I mean, he distinguishes the normal case where you have a factual difference.
Quite so, my lord. So the normal position in a VAT situation is if there has been a hardship application that has succeeded, steps are not then taken to recover the VAT pending the resolution of the first tier tribunal decision.
But there is, as I understand it, there is no automatic postponement of the right to recover.
No.
And the test, if push comes to shove, as it did in the Changtel case, will be whether the appeal is a bona fide appeal with a real prospect of success.
Yes.
So that's exactly the same, isn't it, as for SDLT and income tax?
Yes. That is correct, my lord. In relation to the winding up situation, the usual rule, the same rule.
So you don't challenge Mr. First's submission that, in fact, across all three taxes, the regime in relation to postponement of collection is the same. Although there may be a practice that where the revenue's actually looked at a case and thought that there's hardship, it won't take collection steps.
Unless it falls into a special category, such as the MTIC category, which were cases of particular egregious and extensive fraud.
Is it implicit in the statutory scheme which provides for an exception in cases of hardship, the rule that you pay up front, that the Inland Revenue can't collect the tax if there's been a hardship ruling either by the revenue itself or by the court? I mean, you're relying on the fact that there's an administrative discretion, and the weight to that may be very much diminished if it's simply a dependence on the say-so of the commissioners themselves. On the other hand, it may be arguable that if you have a statutory scheme under which hardship means that you don't have to pay up front, for the result to be wholly circumvented by the collection of the tax anyway, would be a somewhat strange and incoherent legal scheme.
Well, it would. But I think I could probably go no further than the Court of Appeal in Changtel, which was to the effect that, excuse me, the decision of the first tier tribunal on hardship would not of itself, as it were, displace the jurisdiction of the Companies Court, but I say it's the right inference from Changtel that saving it in the exceptional case, the conclusion reached by the FTT is going to be highly persuasive in relation to any application to the Companies Court to wind up. So you've put it to me.
Well, that's true in the case of a decision to wind up, which is ultimately discretionary. But there are other methods. For instance, they could obtain a judgment for the debt, could they not?
Yes, it could. And certainly in those...
That would involve no element of discretion at all.
No. And certainly in those circumstances, if you had a situation where a hardship application had been allowed either by the commissioners or by the first-tier tribunal, and then there was legal proceedings to recover the VAT as a debt, clearly there would be a stark inconsistency, either between different views held by the commissioners at the same time, if they had themselves allowed the hardship application, or a stark inconsistency between the conclusions reached by the first-tier tribunal as to hardship and the reasons why the commissioners were nevertheless seeking to enforce the debt, to recover the money. But
I mean, what I understand is being put to you
yes,
is that there's the constraints on the commissioners' powers and duties to collect the tax would be subject to public law irrationality constraints, and it would be arguably irrational for the commissioners to seek enforcement by any means where you conflicted with a hardship finding of the first-tier tribunal.
well, my lord, that is the yes.
Well, it wouldn't even have to be irrationality, because you can have a statutory scheme which only makes sense on the footing that you can't do it, full stop.
Yes, and my lord, you put it to me whether it was implicit in the scheme. So I don't want to quibble about words, but my submission is that it would be in most cases, in the ordinary case, there would be a very strong inference that it would not be open to the commissioners in terms of public law principles to go ahead and seek to recover VAT in circumstances where the first-tier tribunal had ruled that the hardship exception...
Well, that
Is
may be
it
enough to
possible-
save the rationality of the scheme.
I mean, it's a possible reconciliation of this, that it isn't a hardship to have to pay the tax up front, even if you can't afford to do so, if you haven't got a bona fide appeal. In other words, if the FTT had made a positive hardship finding in favour of the trader, might they not implicitly be saying he's got an appeal with some real prospect of success, so that it would be hard to make him pay the tax up front? Whereas they might say, if there's no real prospect of success in the appeal, why is there any hardship?
Yes.
I don't know whether that's right, but I'm asking whether that's a possible reconciliation of this problem.
It's a logical reconciliation, but the problem about it is that it would require the courts on a hardship application effectively to reach a preliminary review about the merits.
Which is
All that is done is one looks at the means of the taxpayer, his accounts, etc., and you take a view as to whether the taxpayer can pay at that point. There isn't a wider investigation.
No, my lord, precisely so. If, for example, just a perusal of the judgments of the tribunal in this case make it clear that all the tribunal is concerned with on hardship is hardship, simpliciter. There is no, as it were, attempt to evaluate hardship taking into account the possible merits of the claim itself, simply because it would be almost impossible. I think it would be a very difficult task.
You'll be asking yourself whether a different question, namely whether he jolly well ought to suffer the hardship.
Yes. Quite so, my lord, quite so. It would change the text. But perhaps I could steer things, or attempt to steer things in this way. The point about the prepayment rule that is at the essence of this appeal is that it's a rule that could exist to stifle appeals in VAT cases because of the requirement to pay up front, subject to hardship. But I say that if you read the prepayment rule together with the hardship exception, the risk that a VAT appeal will be stifled because the taxpayer does not have the resources, both to pursue the appeal and pay the tax, is in fact a lower risk in a VAT case than in an income tax case, because there although there is no requirement to pay in order to initiate the appeal, the obligation to pay still exists, subject to a decision which is based on an assessment of the merits of the appeal. And so more likely, at least if one looks at it at the level of theory, more likely the possibility in an income tax case that there might be an appeal, there might be a situation in which there is no decision to postpone payment of the tax, and in circumstances where that decision would be taken without regard at all to the financial impact on the appellant in terms of his ability to pursue the appeal, of being required to pay the tax while the appeal was still pending. So if one focuses on the specific procedural distinction in issue in this case, and then looks to the reasons why it is said that that procedural distinction gives rise to less favourable treatment, the fact that appeals might be stifled, I say that Totel's argument about less favourable treatment really starts to crumble, because it's only in VAT cases that the financial circumstances of the taxpayer are taken into account. And that fact means that it is inherently less likely in those cases that financial considerations will stifle an appeal. So, yes, there is different treatment. I don't doubt that for a moment, and I could not doubt that. But I say it is not, in my submission, truly less favourable if you look at matters in terms of what is the risk that an appeal might be stifled. And further, perhaps just for your note, I could draw your attention to what we say in our written case at paragraph 48, which is from page 81 of the appeal bundle at tab 6. These are just further points in relation to the fact that Totel does not itself demonstrate by its submissions that there is less favourable treatment in relation to the respective positions of VAT appellants and other tax appellants. If I could turn now to the last submission, which is in respect of the no most favourable treatment proviso. And again, just to put this submission in terms of context, in terms of the list of issues in this appeal, the Commissioner's contention is that if you conclude that VAT is not sui generis, if you conclude that VAT appeals are similar to income tax appeals, and also conclude that there is less favourable treatment arising out of the differences between the rules for VAT appeals and the rules for income tax appeals, there are nevertheless other domestic tax claims that are similar to VAT appeals and which are subject.
Does this submission depend on the proviso being a completely distinct from the similarity test, as opposed to being part of it? I mean, one view of the proviso is it's simply part of the same broad test, but I think that the submission that you're making now suggests that the test for equivalence may be satisfied in all other respects, and then the proviso comes in and may save something that would otherwise fail.
Yes, my lord.
But I mean, is that your primary submission, or is this a fallback on the basis that we do think they're separate principles?
I'm sorry, Lord, that you think the proviso is separate.
Are you submitting as your primary case that the proviso is a completely distinct rule, or is this a fallback submission?
So I'm failing to grasp the distinction, my lord. As I see it in my submission, the way the proviso works. Rather, it works in situations where the outcome of the similarity evaluation is that there are two or more similar domestic actions.
Yes, you're assuming that the similarity question has been answered and that there's a further question to be addressed, which is the most favourable treatment.
So it operates distinctly, but in the same way that any proviso will usually operate distinctly. You will usually have got to a particular conclusion. In this case, the conclusion there are two or more similar domestic actions.
And you are treating it as a separate test, which
Yes.
arguably it's not. I mean, arguably it's simply part of the explanation of what is meant by the similarity rule. But anyway, but I mean,
Yes.
we'll
Yes,
make your submission on the basis that
yes.
you need it as a separate test, or it becomes a separate test.
Yes, quite. Yes, so to that extent, it is. Yes, I am treating the proviso as a further requirement of equivalence.
Yeah.
But in practice, I'm not sure that the difference of analysis produces any
But
difference.
it does produce these rather odd situations. You're looking if you can find any domestic remedy which is less favourable, then you get home. Whereas one would have thought, as a matter of common sense, one's looking at the generality rather than trying to pick out one.
Yes,
One remedy which
but the first stage of the process must logically, my lord, be to identify candidates which are similar domestic claims, and then to consider them to see if they are in fact similar. And one saw that approach from.
if the object of the exercise, the whole point about this is to ensure that EU remedies are not A, effective, and B, are not sort of singled out for less suitable treatment. But if you come to the domestic scene, you'll find there are all sorts of different remedies which may not be totally coherent, but they don't have and that the EU remedy is not being singled out for worse treatment. It does happen to be treated different but like various other ones. Surely you don't have to go through the process of sort of looking at each one and deciding, well, that's more favourable, that's less favourable.
In practice, that may well not be the way in which a court approaches this task, but in practice, no doubt a court will be presented with arguments that X or Y domestic cause of action is a similar cause of action. The court will then need to decide for itself whether that is right, whether X or Y are similar causes of action. Now, if the conclusion is reached that there are two or more domestic causes of action that are similar for equivalence purposes, and assume that different relevant procedural provisions apply to each of those domestic claims, that is where I say the proviso comes in. Because the proviso comes in because in that situation, it is sufficient for the purposes of equivalence that the EU law claim, the procedures that apply to the EU law claim, are at least no less favourable than one or other of the domestic claims.
As I see it, what you call the proviso seeks to answer a question where on a spectrum of truly comparable domestic claims, which have different degrees of procedural favourability, the equivalence principle requires the EU claim to be placed.
It does, and my lord, it also indicates that the nature of the equivalence requirement.
Yes, well, that's what I mean by where on the spectrum.
That
it only arises if there is a spectrum. If there's only one other domestic truly comparable claim, or all the domestic truly comparable claims have the same and different level of treatment, better level of treatment, then the problem doesn't arise.
Quite so, my lord. The proviso simply has no application. So in the same way that there will be circumstances where the principle of equivalence itself has no practical application because there is no similar domestic action. If there is only one similar domestic claim, then the proviso has no role to play at all.
But it would arise, therefore, in this case, if Mr. First's submission that all tax appeals are truly comparable. So you have to look at all the ways in which our law deals with domestic tax appeals.
Yes, and it's for that reason that I say that if you would take that approach, the conclusion that you will reach is that regardless of the position in income tax cases or SDLT cases, there are other similar domestic tax claims. They were accepted in the Court of Appeal, they're accepted in this court and listed in Annex 2 to the Court of Appeal's judgment, which are subject to the same prepayment hardship provisions as VAT claims. And I say that the existence of those claims is sufficient to dispose of any equivalence argument and sufficient to require the conclusion there is no breach of the principle of equivalence. Now, the claimant's submission, I say, simply runs contrary to an ordinary meaning of the words used by the Court of Justice when it talks about no requirement for most favourable treatment. The claimant's submission is to the effect that if there are two or more similar domestic actions, each subject to different procedural rules, one regarded as better, the other regarded as less good, then the principle of equivalence means that the EU law claim must be matched to the better of the two. Now, that simply does not fit with the language in EDIS at paragraphs 36 and 37. And for the purposes of this submission, if I could invite you to go back to that judgment, it's volume 4 of the authorities. 36 and 37 are on page 13 of that bundle. And as I understood the submission yesterday, it was to the effect that the second sentence of paragraph 36, the one that starts, "That principle cannot, however, be interpreted as obliging a member state to extend its most favourable rules governing recovery under national law to all actions," etc., needed to be understood as referring to all domestic claims, regardless of whether they were similar or not. Now, in my submission, that's an entirely artificial approach to what the court is saying. It's a simple distortion of what the court is getting at. It was then suggested that reading that sentence in that way was somehow the flip side of similarity. Well, it's not. That sentence is quite clearly, in my submission, a qualification of the principle that the court has just stated. It's anticipating a situation where the conclusion is there are two or more similar domestic claims, and anticipating the question from national courts, well, if that's the case, what do we do? What does equivalence require?
Well, yes. The detailed statutory construction is probably not really a very appropriate approach to a judgment of the CJEU, but it depends on whether you're looking at the words "that principle, however," or the following words "be interpreted," because another equally plausible view of the language is that they're saying, however, the equivalence principle does not in itself mean that you've got to extend the most favourable rule. In other words, it's essentially an explanation of how the equivalence principle works in this context, rather than a proviso. And that approach, as it seems to me at any rate, would be more consistent with the submission that you made earlier, that one is looking for a general standard, and if there isn't one is simply applying each tax as a separate island.
My Lord, in respect of the possibility that the second sentence is simply a freestanding sentence, well, I think there are 2 points that could be made. The first is the context. The principle itself has already been described as a principle that rests on a notion of similarity. And so to read that sentence as then being divorced from any notion of similarity, I say would be an unnatural reading of the paragraph, simply as a matter of ordinary language rather than as a matter of close construction. But the further point is that if you then look at paragraph 37, where the court is turning more towards the circumstances of the case referred to it, it starts off by saying, so there's no prohibition against a distinction between limitation periods for actions as between private individuals and actions governing claims in respect of the recovery of charges. And then the second sentence in paragraph 37, the position would be different only if those detailed rules, so the ones governing charges, applied solely to actions based on community law. And so again, it's identifying in practice the the problematic situation being where there is, as it were, a category of special rules that applies to EU cases, and those rules are not relevantly similar to the ones that apply to the national law claims. So simply as a matter of language, I say that the Totel submission doesn't work. But look at the submission in another way. It doesn't actually make sense in terms of an expression of any principle of equal treatment. In this context, equal treatment is aimed at preventing the EU law-derived claim subject to less favourable treatment because of its origin. If an EU law claim is treated comparably with any similar domestic action, well, then it is not being subject to less favourable treatment on grounds of its origin in EU law, even if there is some other similar domestic claim that has a more favourable, a better procedural regime. Now, Totel's response to that was to say, well, it's no answer to discrimination to say, well, I'm also discriminating against these people. But that submission makes no sense. By definition, the other comparators are domestic legal provisions, and so there can be no discrimination on the grounds of the EU law origin. And in any event, discrimination requires more than less favourable treatment. Discrimination actually brings with it the idea of less favourable treatment on the basis of some form of prohibited reason, in this case, the EU law derivation of the claim. And so reading paragraph 36, as Totel seeks to do, simply does not make sense in terms of equal treatment, which Totel says is the underlying principle of the principle of equivalence. Next, Totel says that the proviso, or the no most favourable treatment statement is directed to, is only a situation where the better of the two similar domestic claims is exceptionally or unusually beneficial. And this is where those words in Lord Neuberger's speech in Stringer come in. Now, in the present appeal, the Court of Appeal concluded, and this is paragraph 46 of its judgment, that those words in Lord Neuberger's speech in Stringer had to be read consistently with the judgments of the Court of Justice, or the judgment of the Court of Justice he cited in support of the proposition. I say that that conclusion on the part of the Court of Appeal was plainly correct. There's no reason to think that Lord Neuberger, in using those words, was seeking to put any form of gloss on the Court of Justice's formulation. And again, if he was going to do that, if that's what he intended to do, why would he do it and then cross-refer to the judgment of the Court of Justice in Leves? In particular, there was no basis or no need to take any such approach on the facts of Stringer. The only options in Stringer, as you will recall, were between the limitation period under the working time regulations and the limitation period for claims for unpaid wages under the Employment Rights Act. And so there was simply no need to add any form of modification to the statement of principle as formulated by the Court of Justice. Finally, I should say this, that if Lord Neuberger's words are to be regarded as some form of gloss, some form of addition to the principle of equivalence, firstly, there is no basis for that in EU law, and ultimately it is the Court of Justice that describes what the principle of equivalence means, albeit the national courts decide how it is to be applied. And further, these additional words simply add no measurable standard. What is meant by the notion of a difference that is exceptional or unusually beneficial? It is the sort of matter that will lead people like me to make submissions for hours and hours until the cows come home, but to no practical effect. And so if it is a matter of any substance at all, well then, because it establishes no measurable standard, it has so little going for it that really it should not be regarded as having any life that is separate or goes beyond the way in which the Court of Justice itself has formulated the principle of equivalence. So I say simply that no significance is to be attached to those words. Finally, Totel criticises the Court of Appeal's conclusion at paragraph 47 of the judgment that the no most favourable rules proviso applied. Could I invite you to just to look at paragraph 47 of the judgment? It's in the appeal bundle, tab 7. Paragraph 47 is at page 105. So, what the court says there, and you saw this yesterday, Lady Justice Arden says that she accepts the equivalence principle shares the same jurisprudential root as the equal treatment principle, but that does not mean that it has to have all the same incidence as that principle. The jurisprudence of the Court of Justice shows that it is open to a member state to apply any available set of rules which are already applied to similar claims to an EU-derived claim, provided that an EU-derived claim is not selected for the worst treatment. And pausing there, I say that statement is entirely consistent with what the Court of Justice says in Edis at paragraph 37, in particular the second sentence of paragraph 47. And Lady Justice Arden then continues, no one suggests that that is the position here. VAT appeals are, with respect to the prepayment rule, no different from a range of other appeals, see Appendix 2. Appeals of the kind mentioned in that appendix meet Mr. First's test for similarity. He has not suggested otherwise, so in my judgment, this appeal must fail on the no most favourable treatment proviso alone. There is no need, therefore, for HMRC to justify the different treatment of STLT and income tax appeals. Firstly, as I've already said, the reference to worse treatment, which is a point particularly highlighted by Mr. Firth in his submissions, is no different from paragraph 37 of the Court of Justice's judgment in Edis. Totel's submission that, and as I record it, there was no need to specify a more favourable treatment proviso if all the court needs to do is to look to see that the EU-based action isn't the least favourably treated. That, as I understood it, was the submission. That, again, it is a submission that makes no sense. If the court is satisfied, having undergone the comparative exercise, that an EU law-based action is not the least favourably treated claim as against a range of domestic law comparators, then applying the no most favourable treatment rule is entirely consistent with the principle of equivalence, because in that scenario, the EU claim is not being treated less favourably than a similar domestic action by reason of its origin in EU law. If I could now come to a number of specific points in Totel's skeleton argument, paragraphs 16, 17, 18 and 19. That is tab 5 of the core bundle, and paragraph 16 starts on page 51. Now, 16 and 17 seem to be to the effect that if there is only one comparator, one similar domestic law action, then the principle of equivalence has no application at all, because you have to discount the comparator on the basis that it is the most favourable set of rules. With respect, that submission entirely misunderstands what the Court of Appeal was saying at paragraph 47 of its judgment. The fact is that the no most favourable treatment proviso comes into play, as I've said, only if there are two or more relevantly similar domestic actions. If I could skip over paragraph 18 for a moment, go to paragraph 19 on page 53. That there, if equivalence operates in the way the Court of Appeal has held, the search would be for any similar domestic action that has the same treatment, rather than as it is for any similar action that has more favourable treatment. Now, with respect, that's simply a matter of semantics. It's not a point of any substance. The inquiry is always, are there similar domestic actions? And in practice, the court will always be presented by the parties, or at least by the party contending there are similar actions, presented with options as to what the similar actions are. Now, If there are similar domestic claims, the question is then, what procedures apply to them? And then, are the procedures that apply to the EU law-derived claim less favourable than those that apply to the similar domestic action? So it doesn't matter whether you grasp one end of the telescope or the other. And all paragraph 19 is an argument about which end of the telescope you grasp. The substance of the inquiry remains exactly the same. Turning now to paragraph 18, again, the various cases that are mentioned there are not in any way inconsistent with the Court of Appeal's approach to equivalence at paragraph 47 of its judgment. Again, Totel's submission to the contrary rests on a misunderstanding of what the Court of Appeal is saying. I won't take you to each of these cases, but I'll say something briefly about each of them. Byrne, which my lady for your reference is volume 1, tab 1, at page 185. As the court heard yesterday, the comparison there was with the remedies available against insured drivers. So there were only two choices, insured drivers versus the uninsured drivers. And so on those facts, the no most favourable treatment proviso simply was not in play. The same was the situation in Transportes Urbanos. I took you to this yesterday. Again, there were only two claims in issue. The claim for breach or claim for damages in respect of breach of a constitutional provision or action in breach of the Constitution, and the claim for damages under EU law. FA Iraq. Now, with respect, I accept the point that members of this court have made that what is said in FA Iraq needs to be treated with a little bit of caution, given that the appeal was ultimately withdrawn. If I could ask you to go to that judgment, it's in volume 1 of the authorities at tab 3. There were two primary issues before this court in FA Iraq. The first was whether a claim could be a relevant domestic comparator claim if its origin was partly outside domestic law. And that is the point that is addressed in Lord Kerr's judgment, paragraphs 17 to 25. The second issue was, what is the nature of similarity? What are the criteria? And again, that's addressed by Lord Kerr, paragraphs 26 to 42. Now, in FA Iraq, the primary comparison before the court was between the claim for asylum and a claim for humanitarian protection under the directive. Now, there are references in the course of the judgment to a third claim, a Human Rights Act claim. And there are two that I've spotted. The first is paragraph 16 on page 259. And there, Lord Kerr says this, the issue, this is under the heading the equivalence principle, has a number of aspects. Must the claim to asylum in order to qualify it as an effective comparator be based exclusively on domestic or national law, or is it sufficient that it partake partly of a national law and partly of EU law? If it is a measure that is given effect in domestic law in the fulfilment of a member state's obligations under a treaty, does this affect its status as a potential comparator? How similar must the rights under domestic and community law be? So those are the two broad questions. If there is a more marked similarity between the community right and a human rights claim, how does that affect the application of the principle of equivalence? So at that point, the possibility of a third claim is introduced. If you then turn to paragraph 32, page 263, the material paragraph is 32 and 33. 32 starts as follows: the Secretary of State relies on the Matra and Preston decisions as authority for what is described as a cautious approach to the question of the recognition of one form of action as a true comparator of a community law claim. It is argued there is a far more readily comparable action to the community law claim, such as a human rights claim. the allegedly domestic law refugee claim had even less to commend it as a proper comparator. So, again, the submission there referring to a third type of claim. Then paragraph 33, the respondent disputes the claim there is any significant or relevant difference between the claim to refugee status and the claim for subsidiary protection. It is argued that recognition as a person eligible for subsidiary protection carries with it an entitlement to subsidiary protection status akin to the refugee status that an applicant for asylum acquires. Moreover, the grant of that status carries with it certain benefits, while the human rights claim, which the Secretary of State suggests is a more suitable comparator, does no more than prevent removal. At a fundamental level, both refugee status and subsidiary protection exist to protect individuals from return to serious harm. And so you can see there that there was certainly no agreement between the parties that the human rights claim was a similar domestic claim. And there, that being so, the shortcut that Mr. Firth suggests would have existed by reference to my submissions as to the meaning of the no most favourable rules proviso, that shortcut simply didn't exist. There was nothing in the circumstances before the court that rendered the reference that it decided should be made redundant. And so again, there's nothing in FA Iraq taking at face value that is in any respect inconsistent with any statement of principle by the Court of Appeal in this case. Finally, Totel relies on the judgment of the Court of Justice in Littlewoods. And if I could ask you to turn to that judgment finally, it's volume 3 of the authorities, tab 22 at page 823. If I could, just as an opening point, the questions that were referred are at page 829, at paragraph 9 of, this is the Advocate General's opinion. And you will see that there were 4 questions referred. The first 3 questions are all directed to what was the content of the EU law right to interest in respect of overpaid charges where the overpayment was in breach of EU law. Question 4 was about the principle of effectiveness. And the context for that was this. If the provisions of the VAT Act as to interest were not consistent with EU law, was it open to the court, consistently with the principle of effectiveness, to disapply national law only to the extent of allowing a Woolwich unlawful demand restitution claim, rather than also allowing a mistake-based claim? That was the issue, one of the issues in the claim at that time. What it appears happened must have been that although the questions that were referred did not include any equivalence matter, the parties must, in the course of the written procedures, have been asked to make submissions on equivalence, because clearly those submissions were made. In relation to the Advocate General's opinion, you were taken to paragraphs 47 and following, page 836. I'd ask you to note, firstly, that those paragraphs contain only general statements. There are no specific conclusions reached as to the content of the principle of equivalence or its application in this case. And it is clear from paragraph 48 that the Advocate General there repeats at the end of the paragraph the no most favourable treatment proviso, and makes it clear that that proviso will come into play only if there are several similar domestic interest claims. If you look at paragraph 48, she says this: if in the light of the above considerations, the referring court should ultimately conclude that there are several similar domestic interest claims in respect of which different detailed rules are laid down, there would not, however, already be a breach of the principle of equivalence were interest not to be charged on VAT collected in breach of EU law in accordance with the most favourable rules which apply to one or more similar domestic claims. It is namely settled case law that the principle of equivalence is not to be interpreted as requiring member states to extend their most favourable rules to all actions brought in a certain field of law. And so again, the Advocate General there is clearly working from the premise that once the similarity exercise has been completed, if the conclusion is that there are two or more similar claims, it's at that point that the no most favourable treatment proviso comes into play. Turning to the judgment of the court, there is no statement to any different effect in the judgment. The material passage in my submission is paragraph 31 on page 845. I don't read that to you, but I do say there is simply nothing in that that suggests any different approach to the no most favourable rules proviso. So, my lady, drawing all those matters together, I say the Court of Appeal in this case was correct on its application of that proviso, and specifically there is nothing objectionable at all with the approach the Court of Appeal took at paragraph 47 of its judgment. My lady, unless I can assist further, those are my submissions in response to the appeal.
Thank you very much indeed, Mr. Smith. Thank you. Ms. Eddy? Mr. Firth.
I'm grateful. If I may begin with the question of whether there is less favourable treatment, I would first point out that in the Changtel case, it was actually the non-MTIC assessments that were being pursued through the winding up court, and you can see that at paragraph 4 on page 306. So HMRC's submission that, well, that was an exceptional case involving MTIC is at odds with the actual assessments they were enforcing, which were the non-MTIC assessments.
Which paragraph was that?
Paragraph 4, my lord, in fact. So it's tab 6, page 306. This appeal is focused on 6 VAT assessments that were comprised in the petition. These assessments related to a similar set of factual circumstances that the MTIC assessment were put by HMRC on a different basis.
So are you saying that the comments on paragraph 56, 58 had nothing to do with it?
They are in relation to, as they're called, the dispatch assessments. So the non-MTIC assessments are dispatch assessments. So if you look at issue 2, were the debts based on the dispatch assessments disputed in good faith on substantial grounds?
What are you saying that paragraph's got nothing to do with it?
That paragraph is dealing with the non-MTIC assessments, my lord.
Yes, I'm sorry, I'm being a bit dim. The point being made was this was a very exceptional case, and therefore one can't draw any conclusions from it.
Yes, and the HMRC began by saying, well, this was an MTIC case, and sort of suggesting the MTIC case.
I don't care about that.
No.
Was it treated as an exceptional case?
My lord, there's nothing exceptional about the issues being raised in that case. They are raised all the time by HMRC in various cases.
So what was it being treated by the court, paragraph 58, as an unusual and peculiar case?
Well, what was peculiar is that you had an FTT decision saying, I think you've got a chance of success, and then you've got the Court of Appeal saying, we disagree with an FTT judge. That's the unusual part of the case.
Okay, well, never mind. Thank you.
Well, because the whole point of the case, my lord, is should the company's courts defer to the FTT, where the FTT has concluded the appeals are not hopeless, and they're saying, well, you don't have to defer, although it would be unusual for you to take a different view. And Judge Poole had already taken the view that the appeals weren't hopeless, but he hadn't given very substantial reasons for that, so the court did go behind that conclusion and came to a different conclusion, and that's what was exceptional about the case, my lord, not the actual arguments being made by HMRC. It was suggested that you could imply into the statutory scheme that if hardship is granted, then collection of the tax should be postponed. Well, if that's so, then Changtel logically was wrongly decided, because we have to infer that hardship had been granted because the appeals were proceeding, but HMRC nevertheless were entitled to and did manage to wind up that company. I would also draw the court's attention to paragraph 40 of the Court of Appeals decision, which says, page 310. I have no doubt the judge was wrong in the guidance that he gave. It is true, as the judge said, that the adjudication of the correctness of a tax assessment has been entrusted by Parliament to a specialist tax tribunal, but that does not mean that the question that the Companies Court has to decide is the same or even substantially the same as the one that faces the tax tribunal. The presentation of a petition to wind up a trader which has appealed against a tax assessment is not an indirect way of winning an appeal. The appeal will remain extant even if the trader is wound up. It is simply that there will be a process of collective execution in place that will allow the liquidator, rather than the company's directors, to decide whether to pursue the tax appeal. So the question of hardship and entertaining an appeal is separate to the question of collection, and the Court of Appeal said it was not a hardship and entertainment of an appeal is not, collecting the tax is not an indirect way of winning the appeal. And I also remind the court that in every case, the tribunal itself has power to strike out an appeal that doesn't have a reasonable prospect of success. There is no right or expectation that you can pursue an appeal that has no reasonable prospect of success. And my learned friend's suggestion was, well, you're in a slightly better position in a VAT context because in an income tax context, no one's looking at your financial circumstances, whereas in a VAT context, they do.
What do you say about the suggestion that it might not be open to the revenue if there's a hardship finding to proceed to enforce the demand, either as a matter of law or as an implication from the statutory scheme?
My Lord, I would submit that there cannot be such a principle because that's not what the legislation says. But what would be probably the better procedure would be for HMRC first to apply to strike out the appeal on the basis it has no reasonable prospect of success. And then
the point that I'm putting to you has nothing to do with the question whether there are reasonable prospects of success. The suggestion is simply that if you've got a statutory rule that somebody can avoid paying up front if he can show hardship, it must be implicit that if he can show hardship, it's not going to be enforced against him. Now I'm simply asking for your response to that as a simple principle of logic.
Well, I mean, I said that does underline the sort of irrationality of the hardship test because it has no connection with the merits of the appeal. If you prove hardship...
That doesn't make it irrational at all. It's a completely different question. Namely, if you have got a statutory scheme which simply says you don't have to pay up front if you can show hardship, that it is very strange for the Inland Revenue then to have the right to enforce the thing anyway.
But it doesn't say you have to pay up front.
Well, it doesn't say it, but there are a number of principles of law which are derived from statutory schemes without necessarily being spelt out in those schemes because they simply make no sense on any other basis. Now, I quite see it's not written down there. But what do you say about that possibility?
I can see the logic of it, my lord, that if you're proving hardship, then perhaps HMRC shouldn't pursue collection. But it's not what the legislation says. And it's in contrast to the income tax legislation, which does say that, where you have got a specific provision saying tax collection will be postponed. So there's a clear distinction drawn.
Well, that works in a different way. That's a postponement as opposed to a get out from an upfront payment rule. I mean, they're both techniques that may produce the same result, but that's why they are differently framed.
Well, yeah. Well, Parliament has chosen to frame the VAT rule in terms of entertaining an appeal. It has then deliberately chosen to frame the income tax rule in terms of postponing the collection. So if you were to infer into the VAT legislation and collection will be postponed if you manage to prove hardship, then you're doing something that Parliament could have done but didn't do. But in any event, it's sort of a relevant debate because you do not have the right to pursue a meritorious appeal. Even if you prove hardship, that doesn't stop HMRC or the tribunal striking your case out if it doesn't satisfy the reasonable prospect of success. So the idea that you're in a better position in the VAT context because you can pursue an unmeritorious appeal simply on the basis you haven't got the money to pay the tax is wrong, because if the appeal is unmeritorious, it can and should be struck out. So my submission is that the treatment is the same. You cannot pursue an unmeritorious appeal, whether it's an income tax assessment or a VAT assessment, but VAT has this additional hurdle that not only you must pay the tax unless you can demonstrate hardship. So there is a difference in treatment, and there is no counterbalancing factor as there was in Preston that would lead you to conclude overall there is not less favourable treatment. There's certainly no obvious there's certainly nothing that balances out the disadvantage of having to prove hardship before your appeal will be entertained. So that's what I wanted to say about the less favourable treatment. I then wanted to make one general point, which is that there is no requirement in the case law to show that the reason for the difference in treatment is because it is an EU law claim.
Unless that's implicit or indeed explicit in ADS paragraph 37.
My lord, if it is, then it hasn't been picked up in any of the other cases. And that's the next point I was coming to, is that this minimalist approach is fundamentally at odds with the case law. And it was conspicuous that my learned friend did not deal with or address you on what I say were key paragraphs of the Pontin case and the Leves case. If I can show you first Pontin, and I have shown you this, but because my learned friend didn't deal with it, I just would like to remind you that it's there and it's important. So it's at tab 27, page 951. And in paragraph 56, if it emerges that one or more of the actions referred to in the order for reference, or even other national remedies that have not been put before the court, are similar to an action for nullity and reinstatement, it would be also for the referring court to consider whether such actions involve more favourable procedural rules. If that's a minimalist and narrow inquiry, I don't know what a broad inquiry would look like. The same point is in Leves at paragraph 50, and I've already shown you that, so I don't think I need to show you it again. Then I come to the question of similarity. I've already set out the submission that HMRC's proposition that a narrow approach should be taken is not borne out by the case law. In particular, look at Leves and Pontin, which my learned friend did not deal with. It's also wrong for HMRC to say, as they did, that in all 4 cases considered, the court was simply considering 2 procedural routes for the same claim. That seemed to be the basis for his narrow approach, is, well, the court's just considering 2 routes for the same claim. But in Leves, if I can just show you that, it's tab 21, page 800. Paragraph 49, secondly, it is necessary to consider the possibilities contemplated by the order for reference. It is there suggested that claims similar to those based on the Act may include those linked to breach of contract of employment, to discrimination in terms of pay on grounds of race, to unlawful deductions from wages, or to discrimination in matters other than pay if it transpires on the basis of the principles set out in paragraphs 41 to 44 of this judgment that a claim is similar to one or more of the forms of action listed by the county court, it would remain to be consider whether it involved more favourable treatment. Sorry, less favourable treatment. So there's a selection of different types of claim being offered as a comparator, and the court isn't rejecting that and saying, no, 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 we must be looking at the same right pursued by two different procedural routes. If we can keep Leves open, because I have a couple more points to make on it, but just following that same submission through, in Stringer, the similarity was with claims for a number of other statutory payments of different kinds. That's paragraph 82, tab 5, page 301. In Transportes, the comparison with compensation for loss, any kind of loss, pitched at a high level. And in Ponton, I've already shown you, it was not a narrow approach. I would also caution the court that it is impossible to identify the breadth of the inquiry from cases where a similar action was found, because what is relevant is not the actual comparison undertaken by the court, but whether it would have refused to undertake a broader inquiry if that had been necessary. You can see that at paragraph 49 of Leves, the Court of Justice is considering only the possibilities contemplated by the order. It can't go out and find its own comparators. If I may just jump out of step a little bit and go to the question of what happens where there's more than one similar action, because the points are made by reference to Leves, and we have Leves open. HMRC set out a four-stage test. First, identify candidates for similarity. Second, assess for similarity, decide if similar. Third, if more than one similar action, decide whether an EU law claim is treated in the same way as any similar action, and if yes, there's no breach of equivalence. Well, if you look at Ponton and you look at Leves, they agree with steps 1 and 2, but crucially say that the question, once you've done questions 1 and 2, is whether a similar action is treated more favourably, not whether a similar action is treated in the same way, or even both questions, and that's an important point I'll come back to. My learned friend made a submission on paragraph 53 in response to my submission. I do say it's conspicuous that at paragraph 53, in the actual answer, the Court of Justice does not say anything along the lines that equivalence only prohibits singling out. My learned friend said, well, paragraph 53 begins in view of the foregoing. If you go back to paragraph 50, it says, if it transpires on the basis of the principles set out in paragraphs 41 to 44 of this judgment, that a claim under the Act is similar. And then if you go to 41 to 43, you've got, 44, you've got in 42 the most favourable proviso. Well, that, first of all, my lord, that may support your suggestion that most favourable is part of similarity, because the reference at 50 is go back to 41 to 44 to assess similarity, and within 41 to 44, you've got the most favourable proviso. So, my lord, that might support that suggestion. But nowhere at any point in this judgment does the court repeat the wording that HMRC rely upon for this no singling out principle, or in any of the other cases before this court. My learned friend also relied on the Marks and Spencer's case, Mr. Justice Moses, and that's behind tab 10, page 446. Sorry, I think it's tab 9, my apologies. And he referred you through from paragraphs 58 to 62, but the key reasoning is at 62.
Sorry, can I have a E-page number?
447, my lord.
Thank you very much.
For paragraph 62. And Mr. Justice Moses begins, it seems to me that the jurisprudence of the European Court of Justice requires a comparison between the approach of the member state to the recovery of tax charged in breach of community rules and the recovery of the same tax in breach of domestic rules. Well, I've already made my submission on that it's wrong. You cannot look at how the UK deals with VAT in a purely domestic context because there is no such purely domestic context. All VAT actions are protected by equivalence. I've already made that point. But if we then go into the second sentence, any wider inquiry will invite unnecessary argument as to whether there is a true comparison. Well, that is thoroughly circular. The argument is only unnecessary if Mr. Justice Moses is right. And indeed, the supposedly unnecessary argument as to whether something is similar is precisely the kind of argument considered by the Court of Justice and the House of Lords and this Court in numerous cases. Of those in the bundle, I refer the Court to Leves, Preston, Pontin, Stringer, and F.A. Iraq, all considering the supposedly unnecessary arguments on what is similar and what is not similar. Then Mr. Justice Moses goes on to say, there is no need to widen the range of inquiry if it is recalled that the need for making comparisons stems from the principle of equivalence, which is designed to avoid infringements of community law being dealt with in a less favourable way than infringements of domestic law. The need for a comparison was recently emphasised in the Incoge case. The principle is designed to protect community rights. Adequate protection is afforded by focusing upon the way the member state deals with the same tax in domestic as opposed to community context. Well, I've already submitted that there is no such domestic context. But it begs the question, it really does beg the question that we've been debating before you at length as to what equivalence requires. It doesn't add anything to that debate, it just assumes a conclusion to it. There's a similar problem, if I may now take you to the Court of Appeal in Littlewoods. And page 377, paragraph 133, is the beginning of the three paragraphs where this equivalence issue is dealt with. Now, the incorrect concession is in 133, where Mr. Elliott, in the second sentence, accepts that VARTA contains provisions which are not based on the implementation of the relevant directives, but are purely domestic provisions, so not every claim for overpaid VAT is necessarily a San Giorgio claim. Well, that's wrong, and you can see the M&S case in 2008, which I referred you to yesterday. So the Court of Appeal gets off to a wrong start. But then, crucially, at 135, on page 378, in Littlewoods, the Court of Justice received submissions from the Commission and a number of member states as to what the relevant comparator should be. At this point, I remind the Court that the UK argued indirect tax as a comparator. The Commission was suggesting direct taxes were also a comparator, and you had the Advocate General saying, yes, well, indirect taxes are a comparator, maybe direct taxes are, we need a fresh reference. So those were the submissions. The Commission argued for a general comparison. UK, Netherlands, and France said the comparator should be just indirect or similar taxes. In its judgment, the Court stated that the comparison should be with similar claims, which in this context we take to mean claims for repayment of domestic VAT. I mean, that contains literally no element of elaboration, explanation, or analysis. It's simply a conclusion, and it's contrary to the way the case was argued, because how can that be what the Court of Justice means when it's not what anyone before the Court was arguing for? My next submission on similarity is in relation to Riensma. And if Riensma is a general proposition that you cannot ever compare VAT to other taxes, well, first of all, why did the Court of Justice say in the present case at paragraph 45, and why did it not restate this general proposition in Littlewoods? it would have been a complete answer to the equivalence. There would have been no need to set out the requirement to conduct a similarity inquiry. Then one comes to similarity in the present case. And you've got to consider the purpose, the essential characteristics, and the juristic structure of the cause of action, the appeal. That is what you have to consider. That's what the Court of Justice has consistently said. And as far as those requirements are concerned, all taxes are treated in precisely the same way. There is a unified regime. And I just caution that it's the comparison I'm drawing is appeals against VAT assessments and appeals against income tax assessments, because you can have different kinds of appeals against VAT claims, appeals against other kinds of decision. It's the appeals against assessments, demands for tax. So HMRC come along, put in front of you a demand for tax and say, we'd like you to pay that, please. And you take it to the independent specialist tax tribunal and say, we don't think we're liable for it. It proceeds under exactly the same rules, for exactly the same body, with exactly the same judges deciding across taxes. Now, in other cases, for different treatments, that would not be enough. My point is simply that given we have this starting point of similarity, we have to look for a reason that would justify a different treatment. And that brings me to the purpose of the distinction. HMRC appear to accept now that the person receiving a VAT assessment will not necessarily be sitting on the VAT. In my submission, it's not that they will not just necessarily be sitting on it. You wouldn't expect them to be sitting on it. If it's acquisition VAT, or if it's import VAT, that's not VAT they're going to have collected from someone else, or will be able to collect from someone else. And that's 2/3 of the VAT system.
Well, when you say 2/3 of the VAT system, 2 out of 3 headings in section 1, is that what you mean?
Well, there are three types of VAT, my lord: acquisition VAT, import VAT, and supply VAT.
You're saying 2 out of 3 heads rather than 2/3 of all disputes.
My lord, I haven't conducted any sort of inquiry to be able to tell you.
That was my question. So
Oh,
you were just referring to section 1.
Yes, I mean,
saying there are 3 headings, 2 of them have that meaning. What we take from that will be for us.
what we take from that, my lord, is something important, which is that if you're looking, we're inferring here the reason for the justification. Parliament hasn't set out, here's the reason we've done this, and you can decide, well, you've tried to do that, but you've not done it very well. We're trying to infer the reason. And given that our starting point is that 2/3 or 2 out of 3 limbs of VAT are not paid by a customer, they're paid by the person actually liable, I say that cannot be the reason for the rule. But even in the case of the supply VAT, which HMRC hold up as the key limb of VAT, in the context of a dispute over whether output tax should have been accounted for to HMRC, if I'm the supplier and I don't think my supply is liable to VAT, I have not charged and I have not collected VAT. That's logically true. Otherwise, my customer would dispute, say, well, you're saying you're not liable for the VAT, why have you charged me the VAT? So you're not sitting on the VAT even in a case of an output tax assessment. So in terms of inferring the reason for the rule, I say you just can't infer that the reason is this supposed difference in whether you're sitting on the tax you've collected from someone else.
Well, I wonder if that's right. I mean, were you to lose your appeal, then the price that you charged the customer would be treated as being inclusive of VAT, and you would be sitting on the VAT. But you wouldn't have knowingly collected an additional sum from the customer.
Economically, my lord, I haven't collected VAT. It may be that the initial amount calculated will be by reference to what I've already charged. I may then have to go back to my customer and say, I've lost the VAT appeal. My price therefore has to have VAT added to it, and you should be paying me the VAT.
Well, as a proposition of the sale of goods law, I'm not sure that would work.
My lord, it depends upon whether the price is stated to be exclusive of VAT or inclusive of VAT. If it's stated to be exclusive of VAT, and you later find out
Yes.
the VAT should have been charged,
Yeah,
you
but-
can go back and get the VAT.
Yeah, but if you're saying, if you're operating on the basis that VAT is not chargeable, it might be an unusual thing to do to say that this price is exclusive of VAT.
My lord-
Anyway, but I don't think we can take it further. But
Well, I would simply say, my lord, that would be the good advice in a situation where you're not sure whether the VAT is chargeable, is to state your price is exclusive of VAT to give yourself the option of going back. That's what you should do, my lord.
if you're foresighted, yes.
Yes, my lord. But the simple point is, HMRC accept that you're not always sitting on the VAT, that you collected from someone else. I say that's normally the case. So in terms of can we infer that's the reason for the rule, I say we cannot infer that's the reason for the rule.
Would it be a fair summary, although no doubt not a precisely accurate one, of the other two limbs of VAT, that's the two cross-border limbs, to say that they are special regimes to make the VAT system work in a cross-border context?
They undoubtedly make the system work, my lord, but they're integral elements. In an open economy, imports and acquisitions are just as important as
I'm not saying they're not important.
I mean, I think that can only be a question of degree, my lord, that you sort of say, well, this is what we really want. This is necessary to back that up. I don't think you can take it further than that, sir. My lord, it's a matter of degree how you look at them. And in further point, the final point on the purpose of the distinction is if Parliament, if we're to infer that what the reason is that you're sitting on tax you've collected from someone else, then it's impossible to see why it doesn't apply to PAYE. That is tax that you've logically collected by withholding from someone else. It's the same. So just to summarize my submission on similarity, I say we do have a prima facie similarity because they are subjected to exactly the same regime. And that's more than just it's a tax appeal. It's the regime within which it operates is exactly the same. There are no other differences. It's the hardship rule. That's the only distinction. And then you look at the reason for the distinction, you find there isn't a good reason for the distinction or not one that justifies this rule. The question then becomes, well, what do you do if there's more than one similar action? And I've already made brief submissions on Leves and Pontin, which invite you to go out and find multiple actions if you can. And crucially, miss out any suggestion that if you find more than one, you should exclude anything but the least favorable, the worst treatment, as the Court of Appeal referred to it. But my learned friend says, well, you get there by the most favorable proviso. That's what it's doing. Well, first of all, the terminology is most favorable. So let's consider a case where there are three comparators, each with a graded, more favorable treatment. So you've got the most favorable, you've got the intermediate favorable, and you've got the still better treatment, but least favorable of our comparators. Well, only one of those three is the most favorable, applying the actual wording of the most favorable proviso rule. Does that mean we get the intermediate most favorable treatment? I say that's not what the Court of Justice is doing. And there's another odd consequence of my learned friend's submission, or maybe it's not odd, but crucially missing from the case law. What my learned friend says is that if you only have one comparator, the most favorable proviso is not engaged. If you have two comparators or more, it is engaged, and you only get the lowest. And he says, well, my case at paragraph 19 is a matter of semantics, because I say, well, where's the inquiry for something similar treated in the same way? Well, there's a better way of putting that, which is that if my learned friend is right, you would always have to have two inquiries. There would always have to be an inquiry to find the similar actions treated in the same way, and a second inquiry to find the similar actions treated in the more favorable way. Because only by doing both inquiries would you be able to know whether the most favourable proviso rule applies. So just to put that a different way, if the most favourable proviso rule only applies where there's does not apply where there's only one comparator, it is a necessary part of the test to go out and check whether there is only one comparator. So the Court of Justice should be telling us, in case after case, first find that the similar actions treated in the same way, second find the similar actions treated in the more favourable way. Only by carrying out both of those inquiries can you know whether the most favourable rule is engaged. Because take Pontin and take Leves, the court sets out a number of comparators treated in the most favourable way and says, one or more of these, go and check whether it's more favourable. Why doesn't the court say, and also, while you're looking, see if there's anything treated in the same way? That would be a crucial element of the test on the revenues interpretation, because only by doing that test can you know if the most favourable rule applies or not. And I repeat the submission, which was not dealt with, which, on my learned friend's case, the most favourable proviso was a complete answer to the case in Nichols. But nobody before the court thought that, including the Advocate General. Because other indirect taxes were treated in the same way as VAT. But the Advocate General did not think that was an answer, nor did the court, because the court said you need to go out and consider similarity. So looking at the way the Court of Justice does apply or set out the inquiry in Pontin, in Leves, and what it does not say, I submit it's correct that you can rely upon any of the comparator actions, which by definition are similar and are being treated in the same way, without good reason, subject to the exceptional or unusually beneficial rules. And that takes me neatly and finally to Stringer. If what Lord Neuberger was doing at paragraph 81 was not interpreting the most favourable proviso, I do not know what he was doing. We have to give Lord Neuberger the credit to know that paragraph 42 of Leves did not say exceptionally or unusually
Where did he get it from? I mean, with respect, it's obviously slightly difficult deciding whether Lord Neuberger knew what he was doing or not. But I mean, where does he actually, with great respect, get that qualification from? Because we've got the statement of the European Court, which, for good or ill, is what we've got. Where does he get his gloss from?
I don't know that, my lord. I suspect this court may have a better idea.
Well, can we really apply the gloss when we don't know where it comes from?
Well, my lord, put it this way. If this court provides an elaboration upon the most favourable proviso in this case, and it's looking likely that that might happen, you're not going to get it from a clear statement from the Court of Justice. You're going to get it from...
Oh, we'll do it because it's necessary for the purpose of this case to work out how it applies, but it wasn't really necessary.
Well, it was, my lord,
case.
because...
Well, Lord Walker didn't seem to think it was.
What Lord Neuberger clearly said, if we turn up Stringer, just to, rather than me paraphrase, it's tab 5. Page 301. As Lord Walker explains, Section 23.3 is plainly a provision which is intended to have and no doubt has real value to many employees in relation to many claims based on deductions from their wages, even though I accept that it may on occasion be capable of being a little hit and miss. This is therefore not a case in which it can be said that the appellants are seeking to benefit from the most favourable rules of limitation, which I understand to mean exceptional or unusually beneficial rules. Now, my learned friend's submission is based on him being right that the most favourable proviso is not engaged if you only got one comparator, or all comparators are treated more favourably. But that's not what Lord Neuberger is saying. His lordship is clearly saying, and we get through, I'm applying the most favourable proviso, and this is the reason we get through it. It's a crucial step in his reasoning, my lord, because if he didn't go through that hoop there, then presumably the equivalence argument would have stopped right there. So he has to go through the most favourable proviso to get to its conclusion that equivalence has been breached. It's a crucial part of the reasoning. But whether or not this court considers that Lord Neuberger had a good basis in the jurisprudence of the Court of Justice for his interpretation of what the most favourable proviso meant, HMRC's submission is that if a lower court thinks the Court of Justice jurisprudence does not support an interpretation of the highest court, the Supreme Court of the House of Lords, it is entitled to go behind that court's interpretation of EU law and substitute its own. That is what the Court of Appeal was doing. They didn't say it's not binding on us. They didn't say it's not part of the ratio of the case. They didn't say it's per incuriam. They simply said, well, Leves paragraph 42 does not say what Lord Neuberger said, therefore we're not going to follow Lord Neuberger's reference to exceptionally or unusually beneficial. And that is a recipe for chaos. It would mean that lower courts can simply go behind judgments of this court or higher courts by reference to earlier European Court of Justice judgments that they reinterpret or interpret in a different way. And that, I say, is a recipe for chaos. My lady and my lords, unless I can be of any further assistance, those are the submissions in reply.
It would appear not. Thank you very much indeed.
Thank you, my lady.
And thank you to everybody for your very interesting and helpful submissions. And we will now go away and work out what the answer is. I hope a single answer. You never know. And we will let you know what that is in due course. Court is now adjourned.